Hi everyone, welcome to the new series that we're doing. And I'm here with Grace, and we're really focusing on the H-1B for this live session. We're first going to be talking about the alternatives to H-1B. As most people know now, the H-1B, there might be 100,000, well not might be, but the way it's going to be spelled out. Who does it apply to? How does it affect you? And also whether the lottery will go away because they're going to heighten the selection process for the H-1B, judging by your wage level and high skill. So there's a lot of confusion around H-1B. We're dealing with it day in and day out. And right now, there's a lot of consultations and discussions regarding, well, what's the alternative? If I can't do H-1B anymore, if I wasn't selected this year, what can I do? And so I'm here with our H-1B expert. And you can see a lot of her videos talking about H-1B, talking about EB-2, EB-3, and we're going to be brainstorming a lot. And for the second portion of this live session, we're talking about two L-1B cases that got approved, and we used it as an alternative to the H-1B, right? And so L-1B is a great alternative to H-1B, which we'll talk about, and that way, we can all analyze it together. I understand there's a lot of uncertainty regarding whether or not the president's proclamation will go through, how it will change, what USCIS, what the Department of Labor is going to roll out. There's a lot of lawsuits going on. So we're just going to start by talking about some of the confusion, what we don't know, what we do know, and then we're going to go into the alternative. And during this entire process, feel free to ask questions, right? It could be questions about H-1B. It could be anything regarding immigration. Of course, if we can't answer it, we'll let you know, okay? So it's an hour-long session, and I'm really glad we got Grace to be able to join. I pulled her in last minute. She wasn't ready. She didn't prepare for it. I'm like, you're the H-1B expert. Today we're talking about H-1B. Do you want to join in? So
Of course.
yeah.
Amazing.
So the first question, Grace, is what do we know for sure?
What we know for sure is that the president's executive order said there will be a $100,000 fee for anyone entering into the United States with an H-1B petition filed after September 21st, 2025. So we know that for sure. We know that it's not going to apply to anyone during this year's H-1B cycle. So if you're outside of the U.S. and you haven't applied for your H-1B visa yet because you're scared of this $100,000 fee, well, know that it does not apply to you because it's only for petitions filed after September 21st, 2025. If you're a current H-1B visa holder, it also does not apply to you, even if you don't have a visa, your visa expired, you're in the process of extending your status, that's all fine, right?
Yeah,
So
so that's the good news, right? And that was a lot of the confusion regarding,
Right.
If you already had a H-1B but you left the U.S. and you're trying to come back in, does that 100,000 apply to you? So I think most people are clear on those restrictions.
Right.
Now let's talk about what we don't know.
Yeah, so what we don't know is that it's not very clear yet, or the administration hasn't set forth the clear boundaries, which we might expect closer to the lottery next year. Does it apply to people already in the US, right? So like, for example, if you're an F1 student and you get selected in the lottery and you're changing your status from F1 to H-1B, you're technically not a person outside of the US seeking entry. So would that $100,000 fee apply to you?
Now that's so important because a lot of the lawsuit is surrounding Mr. President, you don't have the authority to impose a 100,000 fee on H-1B applicants because that's Congress's job. So all fee increases, it has to go through Congress. You can't just willy-nilly set a proclamation and say 100,000 on people that's filing the H-1B. Now, in the proclamation, there's a legal ninjutsu that he did that was really clever, saying it's for people who are entering the U.S. The president has the ability to control the borders, right? Because foreign policy, diplomatic affairs are all within the executive branch. And if you watch the reasoning and the proclamation itself and read through it in depth, which I have many, many times, everything that they have said regarding why they created this H-1B policy of this 100,000 fee is to prevent foreigners from coming into the U.S. to do low-wage jobs. And they said, why don't U.S. companies hire from our own universities? Well then, if you are an international student, you got your master's degree, you got your bachelor's degree here, you pay the high price of international students, and then you got an H-1B and then you do a change of status, that fulfills what the president wants. He's trying to prevent a lot of IT firms from overseas who got really cheap college and master's education and then meet the requirement of the H-1B and then coming in to do a low-level job, right? So there is that confusion, whether or not H-1B new petitions but are done inside the U.S. will still have to pay the $100,000 fee. And if not, then does that mean if they apply and they get it, they just cannot leave the U.S.?
Right.
Because if they leave the U.S., they come back, they might have to pay the $100,000, right? That becomes a complication. But at the same time, the Washington D.C. is also in the past few years created the H-1B visa program, so you can get an H-1B visa in the U.S. without having to leave. So there's a lot of confusion regarding that. But I see we already got some questions, so we'll start answering first.
Yeah. So how long do you think it would take for an injunction, for this H-1B lawsuit?
How long will the injunction last? Because the lawsuit has already been filed, right? So likely we're going to see it at least till next year. And again, most of this is about new applications. So for the very handful of unfortunate souls that did not apply by September, which is really quite rare,
Yeah.
right? Because a lot of people got selected by May, by June, so had already 3 months to prepare for the H-1B application. And usually October 1st is when people start working already. So most people already filed by July, by August. So it's quite rare for somebody to hold off that long. But there are people, I know, right?
Well, actually, you have to file by June 30th. So, like, I think the confusion of that September 21st deadline is that that's the deadline if people want to come into the U.S. to start their job on October 1st. And I think that's why everyone's so confused. Like, the timing of this order made it seem like it was imposing a fee for all the people who are selected.
Yeah, and coming in.
Yeah, exactly. And I guess it could apply to a handful of cap exempt H-1B where they can apply throughout the year.
Right, right.
But it was interesting timing, I would say.
When do you think the injunction will start?
Well, that depends, right? If the attorneys are going for a TRO, which I actually don't know.
Temporary restraining order?
Right, temporary restraining order that could go immediately, right? Or are they going to seek injunctive relief maybe closer to when the lottery starts? It's kind of hard to say.
And then it depends on if USCIS is going to follow that, right? Because again, if you file the case and you don't pay the $100,000 fee and there's a lawsuit going on and USCIS is shut down because of quote unquote the government shutdown furlough, and if you guys don't know, most USCIS service filings doesn't go to USCIS. It goes to like a filing clerk. It's they outsource almost all of it. And so, are they going to reject the case or not? So there's a lot of confusion regarding that. And so, if your case gets rejected, definitely don't be disheartened. Try to file again, especially if there is a temporary restraining order on your side.
And then, does an approved EB-2 NIW on an H-1B in the past, does that have an expiration date?
Approved NIW.
And an approved I-140 will always be with you unless you activate it and then you abandon it. So we have seen clients, they activate it, they got the green card, and then they abandon it, then it is no longer useful, it is void. But if you don't activate it, you never apply for adjustment of status, it is always there, and then if you have H-1B under AC-21,
you can extend your status.
Keep on extending the H-1B indefinitely.
Yeah, so explicitly in the order, it does say it does not apply to H-1B renewals, and we can interpret the H-1B renewals either as extensions or renewals as in a new, like, beyond the 6-year limit based on AC-21.
But again, that's based on the proclamation.
Right.
USCIS going to take a couple months to come up with their new order. Should be much more clear.
Hopefully.
Yeah.
So okay, I have a previous H-1B that expired with 2 years of unused time back in 2022. Now, can I use that to get a new H-1B without the fee?
That's a good question. I could try to tackle
job,
it.
currently outside physician. Those are some other facts.
Oh, cap exempt. Oh, that's interesting. That changes it actually, because cap exempt means you are actually not counted towards the lottery at that time. So there's nothing for you to recapture other than you can only stay within a certain limit, right? That is questionable.
And if you've been outside and you haven't used up the full amount of time, then you could try to apply. And that is something that we've been debating at the firm right before this too, because again, we have a lot of clients who are in this similar situation. If they have H-1B right now, but then they're going to leave and take a sabbatical year, And then when they reapply next year, they've been outside of the US, do we apply as an extension or do we apply as a new petition? If it's a new petition, there's a high chance that the officer will say, you need to pay the 100,000 fee because it's a new petition. We are going to try to argue and say it's a new petition, but we're recapturing the number that they've already been selected for, so they don't need to pay the 100,000. But right now, we don't have the memo, so we don't know if that argument will work or not. But that's one plan. So if somebody who has an H-1B, in your situation, you have the H-1B, you left the U.S., they're going to leave the U.S., they're going to take a sabbatical for a year. When they come back, do they file as an extension H-1B? Because if it's a filed an extension H-1B under the proclamation right now, it's okay. You don't have to pay the 100,000 fee. But if it's a new petition, there is a chance that they might require it. And so that's a part where we have to wait for more guidance. Yeah.
Exactly. And because right now, as of USCIS, there is no extra fee that is required to, file a cap exempt. So we don't know, is this going to be enforced at the consulate level at the time when you apply for a visa? Right? There's so many things up in the air.
Is OPT to H-1B a change of status if you're already in the U.S.?
Correct. You're changing your status from F1, right, to H-1B.
Yes.
Okay. Now, I want to make sure we keep talking about H-1B because I know Grace's time is limited. I have all of your other questions, and we'll talk to them. We'll get to the other questions after the H-1B. So yeah, we're still.
Oh, so go back to the news. Okay, all right. So let's talk about the alternatives, right? So let's say worst case scenario, the USCIS issues the memo, and it just cuts across the board. Any new petition needs to pay the H-1B, and let's assume they say it applies to all change of status as well in the U.S., out of the U.S. It applies to cap exempt nonprofit organizations. It applies to, let's assume it applies to wage level 1 through 3. Which will be pretty insane and crazy, but let's say, okay, level wage 1 through 3, you really want this worker, then pay that 100,000, right? So what are some alternatives to the H-1B process, right? For companies who really need foreign workers and for foreign workers who really want to come to work in the U.S. Any ideas?
Yeah, there's not a lot, but I think most commonly if you're a member of a treaty country, so if you're a national, right, with a treaty with the United States, you can apply for E1, which is treaty trader. If you create a company and you're exporting, importing goods, right? Or if you create a business or you invest in a business, you could apply for a treaty trader investor visa. And that's a really good option. I've done it for a lot of students who are coming out of college and they want to create a business. And it can be also a service company, right? In your mind, you might be thinking, oh, I don't have $100,000 to invest. Well, we could do it with a smaller number of investment if you're investing in, let's say you're an artist and you want to create a graphic design firm. I've done that before, right? And you can use your equipment, you can use your computer, you can create a little office, you hire a few people, and then you show all your clientele, and we could do an O1 like E2.
Yeah. So E2, E1 and E2 is definitely great. We're always pushing for that because it is one of the best non-immigrant visas out there. And a lot of people who actually don't know about it. That's why we always mention it first. Now, if you did know about it and you didn't choose E1 or E2, right? You're stuck with the H-1B. Now you can't even do the H-1B anymore. Yeah. What are some alternatives to the H-1B? Two comes to mind, the O-1B and the L-1B. It's easy to remember because they're both Bs. The reason why O-1B is quite nice is because the standard is actually much lower than most people think. If you just research O-1B, what the category is, and USCIS, you'll see, oh, it's extraordinary ability artist. Oh, that's too hard. I'm not extraordinary. If I'm extraordinary, I'll apply for the EB-1A to get a green card. That is wrong in so many levels, right? O-1B as an artist, if you read some of the footnotes and read some of the case law, they explicitly explain that O-1B as an artist, the standard is much lower compared to the O-1A, compared to the business, scientist, athlete, and O-1A is considerably lower compared to the EB-1A get the green card. So when people talk about extraordinary ability green card or extraordinary ability visa, most of the time they're talking about EB-1A, which is much harder, and then O-1A, which is much harder than the O-1B, right? So we've done plenty of O-1B college graduate, essentially first real job, and then they get the O-1B because instead of quote unquote you need to be extraordinary. You just need to be distinct. Still, still distinct. But what do you mean by distinct? Well, the school I went to is a good, reputable school. I'm top 10 of the class. I've won a few awards from junior high to high school. I have letter recommendations. Within the field that I'm in, I'm, particularly more distinct compared to my peers. It's much easier to argue distinction, uniqueness, compared to extraordinary, best of the best, right? So a lot of college graduates, they come out, they apply for the O-1B, and O-1B actually is much better than H-1B in a lot of sense because it's infinite. You apply for 3 years, you apply for 1 year, sometimes you reapply for another 3 years. A lot of people on O-1s can stay here indefinitely, and it's not as strict and you're not tied to one employer, right? Now, O-1B is in the arts, so a lot of people are like, well, I don't do arts, I'm not creative, I'm not. But take a step back and think about that. Creating a digital token, is that art or is that computer science? Designing a beautiful blockchain, is that finance? Or is a blockchain something that's artistic? Try to make a creative argument why you are artistic as opposed to, finance and whatever, right? And so there's a lot of room, especially in this day and age, regarding art, right? Modern art. And so you want to show the work you do, artistic, you have letter recs, and you can demonstrate it. Now, again, it's a harder argument to make. Obviously, if you're a painter, obviously if you're a dancer, it's much clearer that it's art, right? But these modern arts, right, still could potentially apply. You might just have to work for it. So that's the O-1B. Anything to add to that before we take a question?
I was just going to add, we've done O-1Bs for like marketing.
Okay, yeah.
Agents, right? Because you're dealing with artistic ads, right? There's art involved in it, even if you're having a marketing lens. Or an architect, it could be more scientific in a sense, right? Or it could be artistic because you're designing interior design, you're designing furniture, right? So I think there are ways, or even like a film producer or an executive producer, arguably it's business, but also you're dealing with the arts.
And every day,
so we do O-1Bs.
Every day I'm dealing with clients and I'm talking about cases and I'm saying, this is really much more art than it is science, right? It's about arguments. So maybe lawyers are considered
Exactly.
O-1B.
I always say this is more of an art than science.
Right. So in the humanities, right? And so something to really think about, O-1B is a strong candidate in contrast to H-1B. You don't have to deal with the lottery. Now you don't have to deal with 100,000.
Or wage levels.
Or wage levels. And you can work for any employer. So O-1B is actually quite good. We definitely should do more videos on the O-1B, but now definitely want to put it out there. We'll answer some questions and then we'll talk about O-1B.
So I want to talk about exceptions for this 100,000. Who is exempt from the 100,000?
Okay, definitively, this is what we know. Who's exempt?
It's just one line. It says national interest. So this reminds me of the entry bans during COVID, where there was a national interest waiver. Now, we don't see the criteria yet, but if it's similar, then it's probably working for critical infrastructure for the United States, something where you can argue that what you're going to be doing is going to bring so much benefit that you should be waived from this exception. So we'll have to wait and see if there's more details, but you could definitely refer to previous national interest exceptions that we've seen with previous entry bans, and I'm guessing it's going to be something similar.
So what about like a physician, for example?
Great question. So we did that during the COVID. So this is the argument you want to make, and the argument you make is to the State Department, actually, right? Well, you make it with USCIS so they can accept the H-1B, process it, get it approved, and then if USCIS accepts it without having to pay the 100,000 fee, then likely the consulate will accept it, and then if the consulate accepts it, then the customs CBP officers will likely accept it. Yeah. The hard part, honestly, in all of this is how do you get past the mailroom? Because the mailroom people are not really, adjudicators. So if they see you don't have the $100,000 check, well, the memo says you need to, you're making an argument, they don't know, so they reject it. So if you are filing this and you're claiming exception, you need to put in big, bold, round top that you qualify for exception, you don't need to pay for 100,000, have supervisory review. And what do you argue? Here's the main argument that we've used that was very, very successful. Argue if everybody in your profession had to pay the 100,000, people would not do it, cannot do it, and the harm that will cause to the U.S. industry. So in your case, physicians, nurses, The case that we did was an interior designer,
Yeah,
right?
that's right.
Now, the interior designer one, we leaned really heavily on the clients, right? Because again, is it that big of a deal that we can't get interior designers in the United States? Woohoo! But we talked about this interior designer was designing for senior center homes. And the clients who've already been waiting for a long time, and it is during COVID, and they need better living, and they need better, so we leaned into the whole health aspect of senior home living and multi-generational living, and the consulate approved it, right? And so that's the argument you want to employ.
Okay, and I see all the questions about DACA. We will get to them, but I want to focus on H-1B for now. What about cap exempt? Are all cap exempts exempt from the fee? What do you think, especially for like university researchers?
Unfortunately, we don't have clarification yet from the administration. It says all H-1B visa petitions. So if we interpret that just face value, it seems like it does apply to all H-1Bs.
Yeah, and tangentially, we saw a school teacher, right? There are plenty of school districts around the U.S. who need good teachers they are cap exempt, but when they are petitioning for them, now we're seeing that they get pushback, and a lot of lawyer community is saying that's not fair, that's not good. If schools cannot get good teachers, it's not like schools are abusing the immigration system and having all these foreign teachers over, but there's just not enough teachers, right? There's just not enough teachers that are in our schools, especially in some of the more far distant places, and percentage-wise, a good 2% to 5% of all teachers are for foreign nationals who are coming here. And so, if you cut out those 2 to 5%, it makes a huge difference on the workload. Just imagine every classroom increased by 10% of students. The quality of education will decrease substantially.
So what I'm hearing is we don't know. There's very little clarification on the government side, but that's an argument you could make to get exempt?
Well, it's a little bit more pessimistic than that. On the face of it, it looks like even if you're cap exempt, you still have to pay for $100,000.
Correct.
So unless USCIS comes out with a memo that clearly says, no, it's okay, you don't have to pay. As of right now, almost everybody has to pay.
Yeah, or maybe cap exempt because you're either working for a government agency or university or research. Maybe there's a stronger argument for national interest. But again, that hasn't been made clear yet.
And again, I see all the other questions. We will get to them, but I just want to focus on H-1B for now. So I'm on an L-1A right now. Got selected for H-1B in 2025. Firm filed as NTO and not COS for later activation. I have approved the I-140, all filed by the same firm. Now, once L-1A expires, can I use H-1B with that I-140? And will the $100,000 fee kick in?
So that H-1B was approved, so this person was already selected in last year's or this year's lottery, I guess. So in that sense, it shouldn't apply to him, right? Because the petition was not filed after September 21st, 2025. Even if you're applying for your visa later on to activate it, technically it should not apply. I think that would be pretty clear.
Yeah, so just to let you know, all the H-1Bs that we filed, the ones that all got approved, what is our approval rate this year?
100%.
100% approval rate.
I can say that now because we just got a tough RFE approved.
Right. So yeah, 100% approval rate for all the H-1Bs we filed, and all the ones that have left the country went to the consulate, got the visa, and came back.
Yeah.
So we're pending one more from AIT, but we have a couple more people going out. But so far, everybody has come back. So in your case, if you filed the H-1B and it got approved, and then you later on just activate it by going to the embassy or consulate and then getting a visa and come back, you shouldn't have to pay the $100,000.
Okay, so now we'll talk to, I believe we said L-1B
Yes.
as alternative because Grace only has 5 minutes left.
Right. Okay. So L-1B is almost like the baby cousin of L-1A, or it is almost the alternate universe H-1B, right? Because everybody who hates on H-1B say H-1B is displacing U.S. workers, H-1B is lowering U.S. workers' wages, and so H-1B is abused and we need to cancel it. That's the rhetoric about people being against H-1B. L1B completely solves that problem because the idea behind L1B is saying these foreign nationals have such a specialized knowledge, that's literally in their name, specialized knowledge, that when they come to the US, they are needed. And in older L1B cases, you have to even argue that they will not displace U.S. workers, and that there are not enough U.S. workers to do this particular job. So L1B completely addresses the concern that the White House and the public has against H-1B. So whether or not people's, feelings and thoughts regarding H-1B is right or wrong, the rhetoric against it does not apply to L-1B. And so we just filed 2 L-1Bs and they both got approved within 14 days. And 2 L-1Bs were in the US. And think about how crazy this is. They came into the US on a tourist visa, okay? And we did a change of status to L-1B, got approved, and they just immediately worked. Don't have to pay the crazy $100,000 fee. Don't have to do lottery. Don't have to do crazy wage determinations. Now, obviously, these L1B cases, the salary is typically a little higher, but it's not crazy high. They work in the tech field. It's over 100,000. And we were able to make a strong claim that they needed to be here. We didn't even get a request for events. Both cases from the same company, and we filed plenty of H1B and L1Bs for the same company. Right? It's an automation company. Regarding cars and car automations, and it was really important that the people who had the patent and the technology overseas can come to the US. So we're gonna do this success story later, but I'm just saying L1B is an alternative to a lot of the H1Bs. The only caveat is the company that you work for overseas or the knowledge that you have needs to be, acquired overseas, and you need to argue that you cannot find that kind of knowledge and capability in the United States.
Now, how do you get an L1B, especially if you're, for example, a biopharmaceutical scientist?
If you are this particular scientist overseas, see what other subsidiary of the U.S. company, right? So you have the lab that you want to work at. What other partnering affiliates are there overseas? You go overseas, you work for them for a year plus, you have that expert knowledge that needs to be able to be transferred back to the US, and you are the only one who could do it because you did that experiment overseas, then you could come back. So that is the L1B. Again, L1B, the whole H1B fiasco of applying the 100,000 for people overseas is a lot of people who are already overseas. Right? We're not really talking about people who are in the U.S. changing status because, again, like we said earlier, there might be a chance, small chance at least, that if you are in the U.S. and you're U.S. educated, you could still do the H-1B and without paying the 100,000 fee. But there's much to be determined about that. But if you are overseas and you've been waiting and waiting to do the H-1B route, but now you can't because of this 100,000 fee, if the two companies are connected, you could still do the L1B. That's what I'm proposing.
Can I add a little about J1?
Yeah. Oh, Juliana. Uh-huh.
Yeah, so another alternative to the L1B is if you have because L1B is for advanced knowledge or specialized knowledge, right? So advanced knowledge could be information that you can't readily find in the industry, like what Joseph was talking about. Specialized knowledge is something that you can't even find within the company, right? So it's like something patented, something that's specific to this company that you have about, right? About a process or about a product. If you have something like that, but maybe you didn't work for a foreign subsidiary, you could also maybe apply for a J1 specialist. That's for people who are outside of the US who come specifically to a company to do a short-term, up to a year, work that is based on your specialty. So it could either be 10 years of experience, or if you have a bachelor plus 5 years of experience, or if you have a master's degree in a relevant field, then just 1 year of experience, and you can apply for the J1 specialist visa. And if you're interested in J1, which is the cultural exchange visitor visa, and you're outside of the US, you might also be eligible for the intern visa or the trainee. Intern is for recent grads of foreign universities who want to come and work and see what the American work life is like. Or you could be a trainee, so you've worked outside of the US for 5 years and you're like, I want to see what it's like in the US. And when we went to law school, we had a lot of LLMs, right? We had judges, people who were like renowned attorneys in their home country. They came to do a master's degree in the US, and now they're, working in a law firm to gain cultural experience to see what firm life is like in the U.S. So there are programs for professionals who are outside of the U.S. who want to come in lieu of the H-1B. And then also another overlap for H-1B I could see is for the J-1 research scholar. So if you're working for a university or for a government institute or maybe even for the corporate setting, if you can prove that what you're going to be doing is specialized and you're going to be researching for most of it, right? Because I've seen even in financial settings that you're doing research, then you can apply for the research scholar, which is up to 5 years. So it's a little bit longer. And these tend to be more for higher education, so like PhD students. So generally it tend to be like you would apply as an F1 and then you'd be working during your PhD on a J1 and then you would apply for H-1B. But we'll see. Maybe that might be not the route anymore, and you just have to max out your J1.
Yeah, max out J1, and if again the memo comes out and it says if you do a change of status in the U.S., you don't have to pay the $100,000. If that becomes the case, then what everybody should do is apply for the F1, apply for the J1, come into the U.S., study, do what you need to do, and then do a change of status. Downside to J1, maybe you have to apply for a waiver later on if you do adjustment
There's a home
status.
presence requirement. But they updated that list last year,
Yeah.
right? So maybe your home country's not on that list, so make sure you check.
Yeah. Thank you guys for, this is everything about the news regarding the H-1B and all the alternatives, because we've been just, day in and day out doing consultations for all our existing clients and also a lot of new people who are really concerned. So hopefully this live kind of, explains a lot of the thoughts. And if you have more questions, feel free to book consultation specifically with Grace. She's our subject matter expert. Okay. And then we're going to take some more questions on DACA, and then I'll do the L1B success story.
Okay,
Thank you.
All right.
Take all of your microphones.
Yes.
Thank you.
All right.
Okay, great. So, if you have DACA and apply for advanced parole and get a job in a different country, how long can you stay outside?
Great question. The last time I went to talk to the CBP officer about this, they said as long as your advanced parole is valid, and when you're entering in, you show that you went to do the thing that you apply for the advanced parole for, whether it's humanitarian, work, or like visiting family, they generally let you in. Now, with that being said, I've seen people who do advanced parole and stay out for U.S. for like 3 to 6 months because they got like a summer internship abroad, right? A lot of college students who graduated and they got a really good gig and they left, right? So it's not against the law, in violation of immigration status if you end up working abroad.
Can I get deported if I'm on DACA? In my case, I have a clean record and I just renewed 1 month ago.
Great question. This is what ICE officers say, that they can deport you if they want to. This might piss you off. I understand. Let me explain their logic. They're saying everybody who's on DACA is deportable, and the whole executive action is essentially saying we're deferring you to not be deported, but that's like, but you are still deportable. We're just deferring when to do it. So it's not a question of if you're deportable. It's only a matter of when you're deportable. That's premise one. Premise two, ICE argues, and creating the DACA program of extending the deportability of all these individuals, dreamers, was a violation of the presidential powers anyways, and many court rulings have said so. So you are deportable, it's only a matter of when, and even the leniency to allow you not to be deported for a short period was exceeded their authority. So they have full authority to deport anybody they want to. Does that mean they will? That's a different story, right? And so my recommendation, after talking with many ICE officers, is this. If you are face to face with an ICE officer, don't ask that question, okay? Don't press it to them. Don't use your DACA as like a hard shield where you're like slapping them in the face and say, I am DACA, you can't touch this. Not a good look. You know what they're gonna say, you know their arguments, and if it comes to a fist fight, they might likely win. And so by force, by logic, don't lead with that. Of course, having DACA, having deferred action approval is a strong, strong defense compared to if you are completely defenseless, right? If you literally just fresh crossed the border, a couple days ago, plus with a criminal record, of course they have mandatory detention against you. But if you have that DACA protection, you at least have some equity. Okay, it was a long, convoluted.
Yeah, can you sum up? Can I get deported if I am on DACA?
If you are on DACA, they can if they really want to. So don't argue against them saying, hey, I have DACA, you cannot deport me. They probably can.
Okay. Can I have you move
this way?
Okay. Yes, thank you. Can I request for a motion to reopen if I have a green card that is considered abandoned?
So it's kind of complicated. If you only have a green card and you're overseas, nobody has determined it to be abandoned just yet. Even if the consulate denied your SB1 visa to come back into the US, that's just the consulate deciding that you might have abandoned it. That doesn't mean it truly was fully abandoned. Because we have done plenty of cases where like consulates have denied the SB1 visa multiple times, 3 times, and we still got them into the US and renewed the green card and they got it permanently, right? So it depends on what you're talking about when you say it's considered abandoned. Don't assume other people have concluded that you've abandoned it, even if you personally might have abandoned it at some point in time, right?
Yeah, they said they got removed as a child from the US.
Okay, well, in that case, if the government already removes you, if there's already a record, it's going to be very hard to do a motion to reopen or argue that judge was wrong.
What if they, do they qualify for DACA?
If you're out of the US already, you don't qualify for DACA.
I have the H-1B since 2024. Can I travel outside the US for a vacation without a problem?
Yeah, we have plenty of clients who are traveling every single month on H-1B, on any sort of other visa categories.
Have you seen a minor be deemed inadmissible before?
Yes. Yes.
I'm married to a U.S. citizen, and I have DACA. Do I have to get an advance parole in order to get a green card?
Depends on if you entered without inspection. If you entered without inspection, like meaning you crossed the border illegally, you snuck through, you don't have an official stamp, you don't have an I-94, you don't have proof that you were admitted, then you will have to apply for a waiver, which you could still do. We do plenty of those, but it's just a little more tedious. It's a 601. You can look that up. But if you entered with a valid visa, tourist visa, and then you just overstayed, then you don't have to apply for a waiver.
As in, was for the minor, were they deported?
No. So the cases that we come across where they are minor and they're considered inadmissible is when the CBP officer doesn't let them in. So they're not deported because they never even got in to be deported, right?
So yeah, the question, have you seen them get deported on a green card if they were inadmissible? So this is like for a re-entry.
So they have a green card. Are they already in the U.S. or they're not in the U.S. yet?
Presumably they are re-entering. This is, I believe, the boarding school.
Okay. So
I've had a few questions on.
Okay, so a kid been out for a long time. They have a green card. They're entering right now, and the CBP officer looks at them and says, left too long. You might have abandoned it. They could confiscate the green card, put it through immigration judge, give a notice of intent to appear, and now you have to make your case with the immigration judge. And if the immigration judge decides, hey, you've abandoned your green card, you've left the U.S. for too long, your parents abandoned it, then they will officially go into removal proceedings and deport you. Have we experienced that, seen that? No, because all the cases we've done were successful. But I don't want to I'm not boasting here. We've helped people do it without our help, right? We give them the guidance and they do it and they were successful. And then again, all the cases we've done were successful, so we didn't have to go to the immigration judge stage.
And can they do deferred inspection?
It's up to the officer.
Up to the officer.
If the officer doesn't it's just I don't want to deal with this case. It's too complicated. It's not my jurisdiction. Just direct it to TA.
Can I get an H-1B stamp if I already have approved my 797 extension without paying the 100,000?
What stamp are you talking about? Are you talking about like the visa?
Stamp in the passport.
But if you're in the U.S., you don't need a stamp because your 797 already has the I-94, so you're able to stay. But if you want the visa, then you need to leave the country and go to the consulate. They did open up a new visa issuing center in Washington D.C., but that's only for renewals. So if you've never gotten an H-1B visa before, you still have to leave the country to get it. But the new $100,000 law doesn't apply to you, right? Because you already got the H-1B, so you're safe, you're good. But if you haven't even filed for H-1B at all, then the H-1, then it might apply to you.
Right, they say it's a renewal.
Yeah, if it's a renewal, so you can leave and get it and come back. But again, check with your attorney. A lot of times, some clients have really difficult baggage issues in their immigration history. So even though U.S. approved it, if they leave to go to consulate, it's like almost guaranteed denial. So all things being equal, you should be able to get your visa and come back.
Yes, great idea to check with your attorney. We're not your attorney, so we don't know your situation exactly. We just know what you tell us. Is it true that USCIS sees your messages and your browser history when you apply for citizenship?
They can check, and they can do a background check, but to that degree of a browser history, I highly doubt it. But they could say, can I see your phone? And then go through it, right? That's their prerogative. CBP, on the other hand, they can see everything, right? So the customs officers, when you're coming through the border, that's their right. They could just swipe the phone without you knowing, without your consent, even with your objection. They could swipe it and see everything if they want to.
Can I have you push that chair just this side?
Okay.
Thank you. And I'm a permanent resident with an expunged criminal record. Is it not safe to travel? Is it legal to say, am I inadmissible because I'm criminal?
A couple things. You don't want to talk about the expungement with a CBP officer or with any immigration officer at the consulate or with the citizenship or USCIS. The reason is because when a case is expunged in a court, it's generally a state court, even a federal court, and that doesn't apply to immigration. So to them, if a case is expunged or not expunged, it's the same thing. Maybe help a little bit, but you don't want to use it to lead with it, because a lot of times people do that. People say, oh, my case is expunged. So anybody who asks me about my criminal history, it's expunged, essentially using it as a shield to tell the officer to shut up. They obviously really dislike that for that reason, right? So I wouldn't lead with that. With that being said, if a case is not expunged, does that mean you are inadmissible and deportable? No. Plenty of offenses are not inadmissible and plenty of offenses are not deportable even if you're convicted. My recommendation to you, take your court record, the minutes, the conviction, feed it through ChatGPT if you want, or just type it out and feed it in and ask, is this a deportable, inadmissible offense? And then analyze it, right? Because is it a single misdemeanor? What is the conviction? There's a lot of things to analyze. Obviously, if you're really concerned, talk to a immigration attorney, criminal law and immigration attorney combined together that they can really analyze it and give you an official legal opinion. Costs money, it takes time, not necessarily 100% foolproof. So you can use ChatGPT or AI to at least give you a precursor, right?
STEM OPT to H-1B for 2026. Would 100,000 apply because it's a change of status?
That we don't know yet. I'm really hoping that would be the case, but to me, it's a hope. We're reaching for that as a country, because there is logic behind that, right? Everything that they said that they were against the H-1B program doesn't apply to people who are in the U.S. doing a change of status. But again, until the official memo comes out, we don't know for sure yet on that.
Pre-trial petty larceny last year was dismissed and expunged. Should I wait for 751 approval or just apply for N400?
That's a good question. let me take a step back. If it wasn't for this criminal offense that was expunged and dismissed, and if your 751 was pending for a long time, right? It's already been 2 years. It's already been 3 years. You're still married to your U.S. citizen. Our recommendation is file the N-400 to push them to adjudicate your 751 faster, right? So now with this offense, if you apply for the N-400, now you have 2 complicated cases that you have to battle through. So I guess if you have a strong 751 case, you have a strong marriage, maybe you have kids, it's indisputable, but for this you have great moral character and everything else as documents, right? If you have a strong case, then yes, push through both at the same time, fight that battle all at once, get it over with, and get your green card and citizen almost at the same time. If you have a weaker case, I would maybe consider wait for the green card and then apply for citizenship.
Okay, so adding on to this STEM OPT to H-1B, if H-1B doesn't work, I'm looking at EB-2. Are you taking clients for this?
Yeah, we definitely do a lot of EB-2s and EB-3s, right? You saw Grace, she's the attorney that does all of this at our firm. We don't find employers for people, right? So I don't know if that's what you're asking, but if you have an employer that is willing to sponsor you, we would be happy to jump on in a consultation with the employer and you, and we can strategize together how we can win this EB-2 case.
Are CAP-exempt universities exempt from the 100 grand?
We talked about this at length just right now. Here's the idea. From everything that we are seeing, they are not exempt. Chances are they still have to pay the $100,000. However, everyone who is CAP exempt, who's working for university, should try to at least 1 or 2 times make the argument that you're exempt from it, not by the policy, but because of national interest waiver.
So, okay, this is for, I believe it's a citizenship interview situation. So I was given a green card as a child when my parents got their green card. Is that answer okay?
Yeah, that's fine.
Okay. Can DACA apply for unemployment? Will that affect trying to get legal status? I have a U.S. citizen husband.
I believe you can. I'm fairly certain. I'm not 100% sure, but I'm fairly certain because we've seen so many of them. Unemployment insurance is essentially something you have paid for out of your own pocket when you work, and also the employer pays on behalf. You're not taking any government subsidies from the government. It's not like, Medi-Cal and stuff like that. So unemployment insurance is something that is well within your right, but I'm not 100% sure.
My husband came in 2014 when he was 13. Is he eligible for DACA?
You have to go through the actual dates, right? So not just about how old he is when he entered, you have to look at the actual dates and when he entered and how long he continuously stayed. We just did the live session on this last week, so we have all the requirements, and you can also double check it with USCIS. It should be very fast.
So for this EB-2 case, it's EB-2 NIW, self-petition,
I see.
English bachelor's degree, 2 years master's degree, they're working in AI.
Oh, okay. So you want to make the argument, right? And for everybody who's watching who don't quite know what EB-2 NIW is, EB-2 NIW is saying, I have this advanced degree, and normally an employer needs to sponsor me in order for me to get a green card. And in order for an employer to sponsor me, they actually have to go through this long process to try to advertise to the public to make sure that there's no U.S. workers who can qualify for this job. Because if there's one U.S. worker who can qualify for this job, then I don't get the job. So they have to go through this advertisement campaign. And so that's the perm process. And the entire thing could take easily 2, 3, 4 years, right? Including the priority date, depending on what country you're born in. Extremely long time. Now, somebody who wants to apply for EB-2 NIW, they essentially skip the entire advertisement, wage determination, and perm process. So in some cases, it can skip a year and a half, and you can get an immediate result within 2 weeks. But this is what it requires you to do. You are self-sponsoring. So you are saying, I don't need an employer. I'm going to self-sponsor because the work that I propose to do to the United States, to do in the United States, is of such national importance that I deserve to be waived to this process. Essentially, I am so important. The job that I do, the work that I plan on doing is of such importance that I deserve to cut in line. That is the short of it. And the US government created this program, and there are a lot of people who apply, and it makes a lot of sense for a lot of people. You have to prove at least 3 things. Your work, national in scope, generally speaking, it crosses a lot of different sectors, and you have the capability to perform it, right? You can have the best dreams and the best solutions, but if you are incapable of actualizing that dream, then it is not very useful to give you the green card. And then, on balance, on a whole, your proposed plan plus your capability deserve to cut in line, right? Is it a big enough problem? Does a lot of people need it? Can somebody else solve it, right? On a balance, do you waiting a year and a half, does it better the U.S. or harm the U.S.? So in your situation, if you have an articulable idea, you have the plan, you have letter recommendations, you have contracts, you have investments, you have your degree, you have your education, you show that there's a major problem in the U.S. that you're going to try to solve, and maybe it touches on the West Coast and the East Coast. Maybe it touches 3 different industries. Maybe it touches 5 different employers, right? And your solution is not something that other people are doing, or they have done it and failed, but you have a new way to do it, and you're uniquely suited to do it, and you have a good argument, then it is worth doing the EB2NIW. And so we did a lot of videos on the EB2NIW. We showed how acupuncturists were able to get it. So how can you do it, right? If you have a good idea, then let's talk.
Mm-hmm. Yeah, so if that H-1B doesn't end up working out, feel free to book a consultation on our website. And a few more questions, super rapid fire, because it is 12:52. How long does it take to get an answer for 131? It's been 11 months, military parole.
I-131 military parole. Definitely double check with each service center and field office, because they each came out with their own policy, and some things were supposed to get approved very quickly, but because one internal memo that not every officer knew suddenly got delayed. So definitely double check with that field office specifically on the I-131 to see if you could get it faster.
Do you guys do EB1?
We do a lot of EB1As. We don't do that many EB1Bs, but we do a lot of EB1As. You could take a look at our website, take a look at our YouTube specifically, because we, at least 20, 30 success stories where we talk about how we go about doing it.
The government is shutting down. I have my citizenship interview October 24th. Should I go?
Sure, go for it. Yeah. USCIS technically is not shut down. I know the director is saying that they're sort of shutting down. From my conversations with USCIS officers at the field office, that is not the case. USCIS is funded by application fees, and so they are still working. They are not furloughed. They have a lot of priority. Internally, a lot of discussion is that take this time to work on some of the more difficult cases that you've been putting off and catch up, sort of a thing. And now, because the director put out that statement, now it's harder to sue USCIS for being slow, because now they can have a defense and say, hey, we didn't have the funding, we can't adjudicate your case in time. So, I know you wanted it in 6 months, I know you wanted it in 1 year, but now it's going to take 2 years. It's more of a defense thing, but they are still working. So if you have interviews, everything is as is, and a lot of officers are still processing cases at the same speed, if not even faster.
Okay, and our last question, super fast. Can someone who left the U.S. after they were 16 for 9 months still apply for DACA? They've lived here since 2006.
I don't believe so, because one of the requirements is continuous presence. Yeah. I'm sorry to hear that.
And now we will jump into our success story.
The U.S. company is a robotics company that needed these technical engineers to come over to the U.S., and they needed 2 of their senior engineers. They've worked at the China company for several years now. They're here visiting as a tourist visa. Their prior H-1B application somehow got messed up by a different firm. The CEO was extremely pissed off, found our firm and say, hey, can you help out? And so we were looking into it, and They messed up on the H-1B, but luckily you might be able to qualify for the L-1B, which is just as good. And this was before this whole like trade fiasco and talking about the 100,000 fee. And so we looked into it, and like L-1B is actually much better suited for your company because you already have too many H-1B engineers from overseas in the U.S. L-1B is for a specialized knowledge, and it might work better. And they don't care to get a green card anyways, so why don't we do L-1B? They looked into it, they said, yes, let's go. We prepared the application within maybe like a month. We filed it within 2 weeks, case approved, and they're able to stay and work here and with their entire family. So it's a great story, and especially this day and age where people are considering they might not qualify for the H-1B anymore, L-1B is really a good alternative. So let me walk you through exactly what we prepared for them, and maybe you can see if you qualify. So the first thing is you want to establish who the U.S. employer is. What is the U.S. employer? What are they doing? And why are they important? Talk about the national interest about this U.S. company. They already know you're petitioning for a foreigner. Talk about how important this company is to the U.S. economy, to the U.S. culture, to the U.S. National interest. In this case, it's a robotics company talking about self-driving cars, right? So a lot of engineers are needed to make this happen. A lot of technology is evolved. Now, the foreign company, the subsidiary of this company through like a couple other Asian countries, directly employs these two engineers overseas. And they were, leaders over there. Not necessarily L1A leaders, they're not like executives, but they were engineers, right? And they were part of a particular technology that they invented overseas and that they needed here in the US for this next new product launch. Completely makes sense. A lot of people who are H-1B have that. They worked on a particular project. In this case, we have two clients. They each had a patent. All right. It's actually not that hard to get a patent. Even if without a patent, we have helped many accountants come overseas because, again, accounting rules are different from state to country. Imagine from federal to national. And if somebody who's doing accounting for many different countries for the same employer, for the same industry, it's extremely complicated. That type of knowledge cannot just be trained by a CPA here in the US. So anyways, I digress. Those are other cases. The two engineers, they each had a patent. We argued that they've been in the company for several years. They have this job description, they have their work history, and that they needed to come to the US. And this is their job description here. And the good reason why L1B is better than L1A in a lot of instances is because you don't need to supervise that many people, right? You are bringing your expert knowledge here to do your job. You don't need to be a manager, executive. You don't need to hire 5, 10 other people to manage. It's just to do your job. So the US company really wanted that to happen because, again, it is impossible for them to hire a US worker with that special knowledge, or they have to pay a lot of money for the US worker to acquire that knowledge to do their job, right? So it was very easy. The two people came here as a tourist visa. They looked at everything that needed to be done. We did a change of status. They were able to stay in the US, and now they can work 5 years. And then once they're done, they go back. And potentially, if the project is ongoing or there's a next product launch, they send somebody else here, right? L1B is great for that purpose. Now, if the company likes them enough, they can file EB2, EB3 for them, and they can get a green card that way if they want to. So L1B is a great substitute for H1B. The caveat is you just need a US company and you need a foreign company, and they need to be subsidiaries or affiliates. Whether the US company owns the foreign company or the foreign company owns the US company, or they're both owned by the same person. If you can make that happen, and you have a foreigner who is really good at what they do, and the inspiration for me for doing L1Bs, by the way, is when I was doing a lot of these cases back when I just started practicing as an attorney, I saw other people who did L1Bs, and they were specializing in Brazilian chefs. And they brought a bunch of Brazilian chefs over with the L1B. And I was listening to their argument and the way they prepared the case in the conference, and I was like, that's genius, because they're arguing the way you grill the meat, fogo de chao, for example, is a very specialized skill. The culinary art schools here don't teach that, and so you need to bring the skills from overseas, from Brazil to the US through the L1B. I'm like, wow, that solves the chef shortage for this particular restaurant, and then eventually that got manufactured to all the other different arguments. Well, every cuisine in the world is unique in their own home country. The US chefs can't cook like that, right? We might be able to flip burgers and smoke ribs better than anybody else, but we can't do anything else, right? So that expanded into all the other, restaurants and chefs. And I'm like, if that could apply to chefs, why not IT? Why not all these other things? So we started trying to do different things. So again, accountants, anything you can show you have a specialized knowledge and certification is a great benefit. So we did that. L1B is a great method, and just sharing that for everybody who's concerned about their H-1B. If you have any questions on L1B or alternatives to H-1B, feel free to reach out. Take care. Bye-bye.
Okay, and that is our time. Thank you, everyone. We will upload this. The full is on our YouTube. We'll upload some highlights. We'll upload the H-1B news. We'll upload everything. Don't worry.
Wonderful. All right, see you guys later. Take care. Bye.
And yeah, you can book a consultation on our website if you need to.
Yeah. And again, we do this